Hi, everyone. I'm going to get our closed captions up and running while everyone logs in from the waiting room. Welcome, welcome. I hope everyone is staying warm. I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services, and I'm joining you from North Carolina today, so I'm a little bit more bundled up maybe. There's a lot of snow outside. And today we have a great presentation. This is just such an interesting topic to me. I learned about it from Roberto when I was still in law school, I think.
Correct.
And it's kind of a unique thing that we have in Florida. I thought everyone had it, but they don't. So we're going to learn about guardian advocacy and other options in decision making. And Roberto Cruz is our presenter today. He's the Director of Farm Worker Advocacy and Community Lawyering at Florida Rural Legal Services, and he is such an expert on this topic. I feel so grateful to him for doing this, and I see a lot of people are interested, judging by the registration numbers. So just a few notes. The closed captions are up and running. CLE has been approved, so that will be announced at the end and also sent out. And I'll also send out the recording and the PowerPoint tomorrow from Zoom. So be sure to check your spam folder. I think that's where it ends up a lot. But thank you so much for joining us today. And I will pass it over to Roberto.
Well, good afternoon, everyone. And thank you, Christy, for making this presentation possible. Today, I will be talking about guardian advocacy and other options in decision making. We have a lot of ground to cover. For that reason, I will ask all the participants to please hold their questions until the end of this presentation. And with that, let's go ahead and begin. At the end of this presentation, our goal is basically for you to be able to identify what options are available to children turning 18 and in need of assistance in making decisions. We also want to make sure that you're able to determine whether guardian advocacy is the right option for a client. And we want you to learn how to obtain a guardian advocacy appointment for a client. So first, let's go ahead and begin by talking about options. A person with a developmental disability may not be presumed incapacitated and may not be denied the full exercise of all legal rights guaranteed to citizens of this state and of the United States. This is the first premise that all attorneys need to know when it comes to guardian advocacy. People have rights, and guardianship basically limits some of those rights, including your right to choose where you live, to manage your money and property, to consent to medical and dental treatment, to request public benefits, select social activities, picking your friends, marrying, and even finding employment. Now, what happens when you need help making decisions? Well, Florida law offers different options. The important thing to remember is that the legal scrutiny used to determine which option is the best suited for your client will be finding the least restrictive alternative. And that is a very important term, least restrictive alternative. Now, by least restrictive alternative, we go back to Florida law and we look for a definition. And by reading the statute, you can get a sense of what the court is going to do. Mainly, the court is going to issue an order appointing a guardian if it's consistent with the person's welfare and safety, whether it will be the least restrictive appropriate alternative. And the most important thing is that it must reserve the right to make decisions on other matters that are not listed in this order. So if, for instance, your order says that the guardian is going to decide who you're going to marry, then guess what? That's the prerogative of the guardian. If the order is silent, then that person will be able to marry without the consent of that guardian. Now, case in point, the truth of the matter is that your clients are going to be the parents of a child with a developmental disability. And parents sometimes just don't understand. Just because you have a developmental disability doesn't mean that you don't have the right to make mistakes. I've represented children with disabilities in divorce proceedings, in collection actions, and in many cases. And I've also represented typical people in those same circumstances. So just because a person might not have the best judgment in certain circumstances doesn't mean that they don't have the right to make mistakes like everyone else. Believe me, as a parent of a child with autism, as an attorney, I'm telling you, this is going to be the biggest obstacle for you. Just making sure that your client understands the limits of their authority as guardians over their ward or their child. Now, what are the available options from least restrictive to most restrictive? Well, the least restrictive is supported decision-making, followed by banking services, power of attorney, representative payee, advanced directives, healthcare proxy, trust, and finally, guardianship. Let's go ahead and talk about each of these alternatives before we talk about guardian advocacy. When we're talking about supported decision-making, it's important to know that this is a new concept here in the state of Florida. Just back in 2020, 2 years ago, Disability Rights Florida got a Florida Bar Foundation fellow by the name of Viviana Bonilla, who represented this gentleman, Tyler Borjas. Now, Tyler got involved in a personal injury matter as part of the settlement. The legal representative for Tyler asked for a guardianship just to make sure that somebody would be able to consent to the terms of the settlement. After the case was closed and the settlement was reached and the money was provided, Tyler was still under the guardianship. Now we're talking about a person that lives, travels, and works independently. He just needed help making decisions. However, once you get appointed a guardian, it's almost impossible to set aside the order. So Disability Rights helped Tyler get out of the guardianship and develop the supported decision-making agreement. Now, if you look at the concept of this supported decision-making agreement, this is something that could be done orally, but if you want to make it a little bit more formal, you can also make it in writing. There are different types of samples in this website, supporteddecisionmaking.org. And in essence, the supported decision agreement authorizes a designated party to help a person with disabilities to make decisions. That's it. It's all by consent. None of the parties in this agreement has the authority to make the decision for the person with the disability. They can only help that person make the decision. And that's a very important distinction. The next item would be banking services. If we're looking at a person that just needs help with their finances, simply getting a bank account in the name of the person with a disability and of somebody that could help that person make decisions would be sufficient. That would assist the person in paying for things like their rent, their groceries, utilities, and so on and so forth, without having to take away that person's right to contract and to reach agreements and to buy things. We want to make sure that when a person gets involved in this kinds of procedures, that you can also try to establish a direct deposit system because it really helps both parties make those kinds of transactions more efficiently. The next is the power of attorney. You can establish a power of attorney to authorize an adult to act on your behalf. That goes for typical and people with disabilities. When we're talking specifically about a durable power of attorney, we're looking at choosing an agent that will continue to act on behalf of the principal after that person becomes incapacitated. So this is usually useful for people that have been diagnosed with dementia or Alzheimer's. As the disease progresses and the person loses the capacity of making decisions, the agent can help this person make the decisions for them. Any competent adult with a disability or with capacity to make an informed consent can execute this durable power of attorney. The representative payee. If you have a person with a developmental disability, usually you have somebody that may be eligible for Social Security benefits in the form of SSI. If a person does not have the ability to administer those SSI checks, then the agency can appoint a representative payee that receives the paycheck and helps other people with their financial decisions. You do not need a court order to be appointed a representative payee by this federal agency. Advanced directives. Now, these allow a person to state their own choices about healthcare or to name someone to make those choices for them. Now, if you become unable to make decisions about your medical treatment due to an accident, for instance, then that person would make decisions for you. That's the typical case. A do not resuscitate order or DNRO, my apologies, is a form of advanced directive and is highly regulated when it comes to guardianships, as we'll discuss soon. We also have the healthcare proxy, which is used by someone that is incapacitated and has not designated a healthcare surrogate. The healthcare proxy provides the order of people who can make the decisions for the incapacitated person. Usually, the first person would be the appointed guardian, followed by a family member, and finally, their friends. We also have trusts. If a person receives public benefits, we're talking also about special needs trusts that would protect the person with the developmental disability receiving those fundings from losing their qualifications for receiving those fundings. The important thing is that you can continue to use the assets of the trust where you are alive as if you still own them. And finally, we talk about guardianship. That is the most restrictive option for those people that need help in making decisions. And it requires two acts from the court. Number one, a decision regarding the capacity of the ward to make those decisions. And number two, the transfer of all or some of those rights to the guardian. So there are different types of guardianships. You got the guardian advocacy, the voluntary guardianship, the emergency temporary guardianship, the limited guardianship, and the plenary guardianship. Let's first talk about the plenary guardianship. That's the most restrictive form of guardianship. Basically, the court finds you incapable of making decisions. The judge designates a guardian and transfer all of the personal and property rights to that guardian. These kinds of petitions for plenary guardianship can run a client about $10,000. They are very time consuming, very time intensive, and you're gonna need a panel of doctors to support your petition. So it is a costly and long process. Then that's followed by limited guardianship. In those cases, if a court finds that a person is incapable of making decisions in a specific area, it just can designate a guardian to help that person in those specific areas only. So for instance, if you're having problems managing your property, then you can have a limited guardianship specifically for your property. So you can do all of the other things that a person would do, like vote, get married, get divorced, travel, live wherever you want to live, without the guardian's consent. However, if you were going to sell a property, give someone a gift, then those things would need to be run by the guardian in those specific cases. Then you have the emergency temporary guardianship. That's when if somebody is in imminent danger and they don't have the ability to make decisions, you can ask a judge to designate a temporary guardian. And temporary guardianships usually last about 60 to 90 days. They're usually a product of an accident that somebody suffers, and that person doesn't have a medical proxy. So the court appoints somebody to make those initial decisions until this person recovers from their imminent danger. Once that imminent danger is gone, then you can determine whether you want to make that guardianship permanent or not. We also have the voluntary guardianship. This is recommended for people to manage their properties, but that are otherwise mentally competent. Again, this is an appropriate vehicle for people that are usually of a certain age and are losing some of their ability to keep track of their finances, and they just delegate that voluntarily to a guardian. The important thing about voluntary guardianships is that a ward can terminate the guardianship just by going to court. They don't need to have the an adversary proceeding to set aside the ward. And finally, we've got guardian advocacy. The specific point about guardian advocacy is that there's no need to demonstrate the ward's capacity. So you don't need the panel of doctors to intervene. As part of the process, the court will transfer all the necessary rights for the care of the person or property of the ward. And really, this is the least restrictive and costly alternative for people with developmental disabilities. A private attorney will charge between $2,000 and $2,500 to process one of these. And as you will see, people usually have a hard time making decisions on which of these options would be better for them. If your role is just to provide advice and counsel and not legal representation, my advice to you would be to get this potential petitioner, parent, or loved one to go to turning18.org. This is a website that helps you determine what would be the best option and the least restrictive option for the person with the developmental disability. It's totally free. It gives you an idea. It answers a lot of questions. And if we're looking about on a petitioner that's filing to request an appointment as a guardian advocate without an attorney, this is the best way to make sure that that person is on the right track. So congratulations, your client has decided that guardian advocacy might be the best option for them. Well, now we need to make sure that you don't appear on the 6 o'clock news. As you know, guardianships have been the subject of many news cycles, from Brittany to Rebecca Fairley here in Orange County. So let's just make sure that you do things right. First, let's start with the legal definition of guardian advocacy. The statute defines guardian advocacy as the process for family members, caregivers, or friends of individuals with a developmental disability to obtain legal authority to act on their behalf. Now, what does that mean? Well, basically, it means that you, as an attorney, are going to represent a petitioner that's asking the court to appoint them to make decisions for the respondent, meaning in this case, a ward, who is a person with a developmental disability. So remember, your client is the guardian advocate, not the ward. And as such, you have to understand that you're representing the interests of that petitioner, which is counterintuitive when the petitioner is the parent and the respondent is their child. Now, who is the respondent? The respondent is called the ward, and there are certain things that respondent must be in order to qualify as a respondent. Number one, they need to be diagnosed with a developmental disability. Now, what is a developmental disability? Well, if somebody has been diagnosed with mental retardation, not the best name for the statute to use, but that's what the statute calls it. There are far more appropriate names to call it, but there it is. Cerebral palsy, autism, spina bifida, Prader-Willi, Down or Phelan-McDermott syndromes. That's the first thing, a diagnosis. Second thing is that diagnosis has to be rendered by a medical professional before the age of 18, okay? So if we're looking at a person that has a diagnosis after the age of 18, this person would not qualify for this particular process. And number three, it needs to constitute a substantial handicap that can be expected to continue indefinitely. So it cannot be a temporary issue. It needs to be something that is permanent. And it also needs to be a substantial handicap. Just because you are diagnosed with autism before the age of 18 doesn't mean that you have a substantial handicap. Types of guardian advocacy. Well, there are basically two. You have the guardian advocate of the person and the guardian advocate of the property. Important distinction. When we're talking about the guardian advocate of the person, that guardian can make some financial decisions. We're talking about handling some financial aspects. But when we're talking about property, when we're looking at vehicles, homes, stocks, bonds, and other kinds of investments that are not necessarily part of a person's daily living activities, then those are property decisions, and you need to request a guardian advocate of the property. Both can request government benefits. So the guardian advocate of the person can request Social Security benefits. They can also be designated as a representative payee for Social Security purposes. What they can't do is administer things like whether a person has the right to sue or defend lawsuits, making substantial gifts, handling contracts, or actually managing properties. As you will see, reporting requirements for guardian advocate of the person and versus property are substantially different. For the property, you are best served by hiring an accountant. Now, are the powers of a guardian advocate the same as the powers of a full guardian? Well, as any lawyer will tell you, for any question that you ask them, it'll depend. And it really will depend on not only the particular aspects of the case, but in which county you're filing your petition, what judge will look at you at the petition, and the kind of support that that person needs according to the medical opinions issued by that person's physician. For instance, there are more conservative courts and there are more liberal courts. If you present the same case in a conservative court, you will definitely have a different list of things that guardian will be able to handle than if you go to a more liberal court. It's just one of those things that cannot be predicted. Guardian advocate has the same powers and duties as a guardian under Chapter 744, limited only by the court's order. Okay, so that's really the gist of it all. The guardian advocate appointment order will delineate the areas in which the advocate will be able to help the ward make decisions. Areas that are not listed will remain as rights for the ward. So the guardian cannot just assume that they can intervene in every aspect of a ward's life. So finally, third, let's talk about how to obtain a guardian advocacy. Now we're going to look at the actual process. First of all, does the client need an attorney to become a guardian advocate? General answer, no, not really. There are two exceptions to that rule though. Number one, Florida law no longer requires that a petitioner have an attorney unless there are delegated property rights. So if it's a guardian advocate of the person, you don't need a lawyer. If it's a guardian advocate of the property, you need a lawyer. And number two, when it's required by the court. This usually happens when there's a potential conflict of interest between the petitioner and the ward, or there is some history of mishandling funding by the petitioner that's going to handle the funding that's going to be provided for the ward. That's usually these kinds of cases. Also, when there's a criminal history attached to the petitioner, the courts will usually require that a petitioner to be represented. The exception to those exceptions are that the petitioner can self-represent if they are the representative payees of government benefits. All right, so we're gonna try to keep it as simple as possible. There are 5 steps when filing a petition for a guardian advocacy. Number one, you gotta find the forms online for your judicial district, okay? There are basic forms that you can get from the probate rules, but some judicial circuits have their own forms. So first look for your judicial circuits forms and then supplement that with the probate rule forms. Step 2, file the forms in court and serve a summons to the respondent or the ward.
I didn't get that. Could you?
Now, this usually happens, as we'll see, because a lot of your clients, if you're a public interest lawyer like I am, will want a fee waiver, and they'll need to go personally to the clerk of court to file this specific form. So that's why that step 2 is there. Number 3, request a background check for the petitioner. Number 4, you need to facilitate the meeting between the ward and the ward's counsel, because yes, the ward will be appointed counsel. And number 5, you will have a hearing in court. Starting with step 1. How can you find the forms online? Well, again, first you go to the Florida Rules of Probate Procedure after looking at the circuit court, and the typical forms are listed right there. If you have a camera, take a picture right now. You need the petition to determine incapacity, petition and order of guardian, letters of guardianship. The 2 and 3 are basically proposed orders for the judge to sign. Then number 4, the guardianship initial annual plan. That's basically a care plan that involves living situation, medical care, and relationship with the community. Number 5, the actual petition, notice and order of appointment. Number 6, the guardian advocacy, letters of guardianship 2, is you're going to receive 2 sets of letters. One is for you and for the court. The other one is for third parties that may need a copy for their purposes. You're also going to need form number 7, which is an inventory of all the ward's assets. Number 8, an application for determination of civil indigency status. Remember, if your client qualifies, you should have them waive the filing fee along with the service of process fee. And that waiver will be awarded if this application is accepted. In order for the application to be accepted, that the petitioner needs to go personally to the clerk's office and get this processed. The clerk also has its own application for appointment as guardian advocates, and they're going to require that petitioner to include their employment history, their financial assets, things of that nature, any crimes of moral turpitude or any crimes at all. They're going to make an assessment through that application that you submit. You're also gonna need the application for service of process with the local sheriff's office. Number 11 is very important, is the physician's report form. The ward's physician needs to complete this form and needs to list the areas in which the ward needs assistance. If you say that the person needs assistance with financial affairs and that's not included in the physician's report, guess what? You don't have sufficient evidence to support a request for that delegation of power. So whatever you want as a petitioner needs to be included in that physician's report. And number 12, and this is kind of new, but it's important to add, there's also a supplemental form for no DNR orders. It's just a statement saying that you have not requested a do not resuscitate order for the person that you are either already the guardian for, or the person that you are requesting to be a guardian for. There is a history behind this form number 12. We don't have time to discuss it, but it is very interesting. In another segment, we might be able to talk about it deeper. Finally, once you got the forms, you need to make sure that these forms are the ones that you actually need. Why is that? Well, because, like I said, each circuit has its own packet. They actually sell the packet in the clerk's office. So you can go to the clerk and just pay a fee, and they'll give you the packet. You fill it out, submit it, and that's that. But those packets are also available free of charge in each of the clerk of court's websites. So all you need to do is just find your specific circuit, go to the website, and just search for those forms. Each circuit will have their instructions of what forms they want you to file, okay? So make sure that all of those forms that specific circuit is requiring, you have in your packet when you submit your petition. And again, each circuit deals with these kinds of processes differently. Now, aside from what each form provided illustrates or requires, this is what the Florida statute requires the petition to have. Number one, the petition must be executed by an adult person who is a resident of the state. Sometimes you will have petitioners from out of state trying to be appointed a guardian advocate for a loved one in Florida. That's not necessarily something that can be done. The alternative to that is to have the petitioner name guardian advocate in Florida, and maybe have a substitute guardian advocate with the approval of the court that lives out of state. That I've seen approved, but the primary guardian advocate needs to be a Florida resident. Next thing is that the petitioner and his or her relationship to the person must be included in the pleadings. So if the petitioner is a parent, family member, friend, or entity, they need to disclose that in the petition. They also need to disclose the name, age, county of residence, and present address of the person with a developmental disability. They need to allege that the petitioner believes that the person needs a guardian advocate and specify the factual information on which such belief is based. That's where the physician's report is so important. Whatever the physician report says needs to be included as part of your allegations. Also, specify the exact areas in which the person lacks decision-making ability. So you can't say this person needs assistance in all daily activities of life. It cannot be that broad. It needs to be specific. This person needs ability managing their finances. This person needs assistance dealing with their personal hygiene. This person needs assistance in handling medical decisions, so on and so forth. It used to be that some forms provided things like the right to vote, the right to marry, the right to socialize. Those things have been stricken out of those old forms because they have been found to be just outside the powers of the guardian advocate. Some people will still try to put them in, but and it'll depend on your judge whether they'll approve them or not. But that's not necessarily going to happen in certain areas of the state. Legal disabilities. You also need to specify what the specific disability we're talking about. If it's autism, then it's autism. If it's Prader-Willi, then it's Prader-Willi. But whatever that physician's report says, that's what's going to be included as the legal disability under the guardian advocacy statute. You also need to state the name of the proposed guardian advocate and the relationship of that person. And like I said, you need to look at things like healthcare services, residential services, and other services. And the reason why this person should be appointed to help the person with this disability make these specific decisions. Now, this is the physician's report form. As you can see, it's plain. This is just supposed to be a guide. You can use this as a template, or the physician can write their own opinion without using this form. The important thing is to include the legal disability, the specific factual information concerning that person's condition, and number 3, the exact areas in which the person lacks decision-making abilities. So legal disability, autism, special factual information. This person does not have the ability to make decisions regarding payment of rent, utilities, or groceries. And then number 3, exact areas in which this person lacks decision-making abilities. It is this physician's opinion that this person lacks decision-making abilities in financial issues, period. Now, of course, once you complete the forms, the next step is to file the forms in court. You need to tell your client or the person that you're advising, if you're not representing them, to make 3 copies of the form. One goes to the court. The second one goes to the sheriff or the person that's going to provide a service of process to the ward, and then the client should keep a copy for themselves. They need to pay the filing fee if their application for determination of indigent status is rejected. Step 3 is requesting a background check. Now, this is a level 2 live scan background screening. So they're going to take the petitioner's fingerprints, and that report will be sent directly to the clerk of the court. So you cannot ask for the report to be given to you so that you can file it in the court. No, that report will go directly to the clerk for their review. Number 4, once you file your petition and the ward is served, the court is going to designate an attorney for the ward. The attorney for the ward is the attorney for the ward. It's not the attorney for the parent. And they're going to be looking at the ward's interests. They're gonna look at the evidence that you provide to make your case. So that physician's report that you submit with your petition is not going to be enough. Remember, you're going to have a hearing at the end, and you need to provide evidence to support your claim at the end, and you need to exchange that evidence with the ward's counsel. Now, sometimes the ward's counsel will ask for more evidence than the one that you have in order to maybe facilitate issues when you go to the final hearing. So yes, it's an attorney, and sometimes these procedures can become adversary. So, my best advice to you would be just to work with your ward's counsel. When we're talking about evidence, remember the three things that we need to establish. Number one, legal disability. That's proven with a medical diagnosis of developmental disability before the age of 18. That's proven with medical records. Number two, special factual information. If you want to look at the facts that support your claim that this person needs somebody to help them make decisions, you need to include things like the school's individual education plan or IEP, a behavior analysis evaluations or plans, psychological evaluations, and most of all, a lot of wards councils require IQ tests. And the reason for the IQ test is that if the person's IQ is less than 75, then the wards council will basically go along with you. But if it's more than 75, then that's when things are going to get a little bit more adversary. You're going to have to explain a little bit more why this person needs a guardian advocate. And number three, accept areas in which the person lacks decision-making abilities. That's accomplished by submitting medical opinions. So the template that I presented should be enough. However, wards council may believe that it's not enough. I've had cases where the doctor fills out the form and the wards council says, I don't like that form. I want something more official with the doctor's letterhead. Well, you know what? The rules don't say anything about letterhead, but if that is going to make the wards council happy, then why not make it into an opinion written in the doctor's letterhead. And number five, you finally get to your hearing in court. This is where the court is going to review the petition for appointment of the guardian advocate and determine whether there are less restrictive options available to help the ward make decisions. And again, depending on your judge, you will get the order or your petition will be denied. This is when I'm supposed to tell you that a good lawyer knows the law and a great lawyer knows the judge. So know your judge before you file your case. Talk to other attorneys that have filed similar petitions with that particular forum. And that way you can get a sense of what you will need in terms of evidence to convince the court that it is the least restrictive alternative to order the appointment of a guardian advocate. Now, these are the most common factual and evidentiary issues that you will find. Like I said, the respondent's IQ is over 75. Respondent has good grades at school. Respondent has a job. They live independently. They actually go to the university. They have a driver's license. That's for the respondent. For the petitioner, well, the petitioner is broke. They have a criminal background, bad credit report, and the petitioner is not a family member. Typical case is when we have a third party intervening in the process. It's usually a co-parent that is not named as a co-petitioner, somebody that is not necessarily in good terms with the petitioner and wants to influence the process. And it happens a lot. So basically what's going to happen in the hearing is that they're going to look at whether this person really needs somebody to help them make decisions, or whether this kid is just adulting. Okay. I mean, remember when you were 18 years old? 18-year-olds, have problems with hygiene, making medical care decisions. They make horrible fashion choices. They have their own political beliefs, religious beliefs. They incur in debt. They don't pay their debts. They have questionable friends. Who didn't have a questionable friend? They have visits to places of ill repute, at least in the eyes of the petitioner. Oh my God, he went drinking with a friend. Well, he's 18 years old, and there are places that allow 18-year-olds to drink. Sexual activity, that always comes up. Spending habits, marriage and divorce. So, these issues even become important in other cases that are being filed parallel with guardian advocacy issues. So, yeah, it's not an easy decision. Parents need to be educated. In order for parents and for you, if you want to get a sense of the type of hard decision that we're talking about, there's a new series in Amazon Prime Video that just started this week called As We See It. This is the story of 3 individuals with autism that are adulting. And you see the parents and their loved ones, making the decisions on whether to exert more control over their children's lives or just to step back and let them be independent. It's not an easy decision. So, as part of your advice and counsel, tell them to watch As We See It. It may help them get some perspective on whether their kid really needs guardian advocate, or whether they're just merely adulting and they need somebody to help them make decisions. Now, in the case of a dispute that cannot be resolved in court, your best course of action is to mediate. Before you go to the hearing, you can ask all the parties, the wards of counsel, the third party, everyone, just to meet with an elder caring coordinator. An elder caring coordinator is an impartial third person who is appointed by the court or designated by the parties and who meets the requirements of Florida law. The role of the elder caring coordinator is to assist the parties to elder caring coordination in a manner that respects the elder's need for autonomy and safety. You can substitute elders with person with a disability. What the mediator is going to do is just to prepare a care plan that everybody can agree to and submit that proposal to the court, and that way you will have basically an undisputed resolution for your petition, and this is really the most efficient way of resolving the dispute. If you can't, then you're just gonna have to go to court, make your case, and let the court make the decision. Now, let's say that everything goes well and you got your order. So you're gonna get an order appointing your client or the petitioner as the guardian advocate. You're going to get the letters of guardian advocacy. Those go to the guardian. And then you're going to get a second set of letters of guardian advocacy for third parties that may have interest in this decision. Once you have that, the guardian advocate is going to have a fiduciary duty and must answer to the court. The guardian advocate's rights are limited by the order and by the type of guardian advocacy that they have. If the guardian advocate needs greater rights, they will need to seek a court order for those. Okay? There are certain decisions that need the approval of the court, and they are listed in the statute. Within 4 months of the appointment, the petitioner, the guardian advocate, is going to have to complete a court-approved guardianship education course. There are several forms in which these courses can be taken. In Polk County, for instance, you get a DVD. You look at the DVD, you certify that you've seen it, so you submit that with the court, and that's that. In Orange County, you actually have to go to a course, which is not cheap. And after you complete that course, then you get certified. Guardian advocates must also file an initial report within 60 days of appointment, setting out the mental health, medical, and social and personal care services needed for the person with developmental disabilities and how they will meet them. This is the plan, the care plan that we were talking about, that is usually done with the elder caring coordinator or mediator. A similar report needs to be filed with the court annually within 90 days from the anniversary date of appointment. So every year, you need to submit an annual report. And finally, a guardian advocate of the property may have additional duties. For instance, a more thorough accounting of the property. Okay, there are a lot of forms. That's why you need an accountant to be involved in this particular form of guardian advocacy. Now, we got about 5 minutes for questions. So please feel free to ask away.
Thank you for a wonderful presentation. I love the way you lay it out so clearly and comprehensively. And I have to say, my favorite quote from you today was, "People with disabilities deserve to make mistakes just like everybody else."
That's right.
Which one of us has never made a mistake?
Exactly.
And just a quick point, this PowerPoint and the recording will be shared tomorrow via Zoom along with the CLE certificate. So just check your spam folder. I have a feeling that's where the Zoom emails go. The CLE number is 2110536, N as in Nancy, and I will send that out tomorrow. It's also in the chat. So we did have a couple questions come in. The first one is about a durable power of attorney. Are you familiar with those?
Yes, yes.
Okay. With a durable power of attorney, can the agent named in the POA terminate an attorney-client relationship for the principal? Can the affected attorney argue that this would be unethical and insist that the principal must terminate the relationship?
Well, you know, again, I'm going to have to give you the attorney answer. It depends. We're going to have to look at the actual language of the durable power of attorney to establish the causes in which the relationship can be terminated. So, you know, for the person that asked the question, if they want to send me an email, and we can talk about this a little bit more openly, of course, with their client's consent, we can definitely discuss it. I will, let me see if I have, okay, no, all right, well, my email address is just my name, roberto.cruz@frls.org, just like
Okay, putting that in the chat.
Perfect.
All right, thank you. So the next question is, must the ward consent to having a guardian advocate? In dependency court, a judge can order it. So what happens if the ward doesn't want a guardian advocate?
Okay, when we're talking about dependency court cases, those matters will be dealt by both courts at the same time. So you're going to have the dependency case and the guardian advocacy case seen simultaneously. Now, those cases are a little bit more complicated than the typical guardian advocacy, and they do have different procedures than the ones that I explained. So again, for that specific case, I would ask the person that made the question to send me an email, and I will gladly go over the specific requirements for those proceedings.
Perfect. And next one, if a young adult with a disability is in foster care and needs a guardian advocate, but doesn't have any family members and is in a group home, can they still be appointed a guardian advocate without a petitioner?
Usually, when a person with a disability is 18 years old or older and they live in a group home, the group home can serve as the petitioner for the guardian advocate. That's typically what happens, and it happens a lot usually because that 18-year-old is going to have to make decisions around their health, and they're going to have to petition for public benefits and manage those things. So if it's just a representative payee, that's one thing. But if they need to make medical decisions, usually you can have the group home manager appointed as a guardian advocate.
Okay, interesting. And we had a question in the chat. Let me see if I can find it. So this person said that they thought to be deemed intellectually disabled, the person had to have an IQ of 70 or less, but you mentioned 75.
It's really it's between 70 and 75. So it all depends on the facts. You can have an IQ of 70 and still just need some kind of help making decisions, and you can have an IQ of 80 and still need a full guardianship. So it all depends on the circumstances of the case. But it really depends also, like I said, on the ward's counsel. If the ward's counsel is satisfied with 75, then it's going to be fine. If the ward's counsel will only be satisfied with 70, then you need to work with that ward's counsel.
That makes sense. Do you have time for one more question?
Sure.
Okay. Is there a sample durable power of attorney that a person with developmental disability has signed? Most durable power of attorneys are difficult to understand, and the person is wondering if guardian advocacy can be used as an alternative.
With a durable power of attorneys, it is really, that's a question of ethics. Really, the attorney needs to determine whether the client, if you're the attorney for the principal, whether your client has the capacity to understand what the durable power of attorney actually means. Okay, there are actually, I think that Christy has some videos in that talk specifically about this area. But yeah, this is there are basic steps for people that an attorney might suspect might not have the mental capacity to understand what they're doing. So I will I will leave that to Christy because there are some videos on it on the YouTube page. Yes.
I will put the link to the YouTube. Thank you for the reminder in the follow-up email. And there's an ethics playlist. And there's also, I think that course Roberto is referring to might have been in the Elder Justice Conference playlist. So check out both of those. We had one more trickle in. How often does the Ward's Council disagree with the guardian advocate proceeding?
It really all depends on the forum. There are some counties that have a specific process to appointing a Ward's Council. If my experience has been that if it's a government agency that is usually appointed as the Ward's Council, that you'll have a bit more opposition than if it's a private counsel that's recruited by the clerk. So that is not a rule. That is just experience. So you gotta look into that.
Thank you so much for sharing all your experience and expertise with us today. I really enjoyed this and we got lots of compliments. I hope you can see them in the chat.
Yes.
Lots of thank yous and compliments. So I really appreciate you doing this. If anyone missed it, the CLE number is 2110536N, and I'll send out all the materials tomorrow in case you missed anything. So thank you so much, Roberto, and thank you to everyone who joined us today.
Thank you, everyone, and have a great day.
Have a good afternoon. Bye-bye.